In the name of God, the most gracious, the most merciful, peace be upon you all. In the first episode, we learned that there are numerous instances where, according to the understanding of our traditional scholars, the division of inheritance as stipulated in the Quran cannot be practically executed. In this video, we will explore if, according to the traditional scholars, the Quranic division of shares is not feasible, then how do they distribute the inheritance in such cases? Are they able to resolve the complications that arise in the implementation of these divisions? And do the solutions they offer align with their own interpretation of the Quran's original scheme of allocation? We shall examine the same three scenarios and assess how the inheritance is to be divided among the heirs when the shares, as per the traditional scholars, cannot be allocated as prescribed. In the first scenario, the parents were to receive 1/3, 33.33%, and the daughters 2/3, 66.66%, while the husband was entitled to 1/4 or 25%. However, the total estate amounted to only 12 rupees. After giving rupees 4 to the parents and rupees 8 to the daughters, nothing remained for the husband. How then is the husband's rightful share to be given? According to our jurists, since the husband cannot be granted his full 25% share under these conditions, the only solution is to proportionally reduce the shares of all heirs. In mathematics, a uniform proportional reduction is carried out in a specific way. By applying this method, it is possible to extract some amount from the original 12 rupees to accommodate the husband's share. Thus, where the mother was originally entitled to 1/6 or 16.66% or 2 rupees, her share is reduced to 1.6 rupees. The father's share is also similarly reduced to 16.66% to 1.6 rupees. The daughters, who were previously entitled to 2/3 or rupees 8, will now receive 53.33% or rupees 6.4. Consequently, even though initially nothing remained, we now have rupees 2.4, 20% of rupees 12, which can be allocated to the husband, who was originally owed 25%. This method, according to the traditional scholars and exegetes of this ummah, is called all. The entire ummah, with the exception of the Shia scholars, has consensus on employing this method whenever such a situation arises. According to the jurists, this matter first came to light during the caliphate of Hazrat Umar, may God be pleased with him, who was the first to implement all, reducing the shares proportionally. Since then, this doctrine has been universally accepted and practiced throughout the Muslim world, but let us now assess whether the outcomes of this solution, attributed to Umar, may God be pleased with him, actually conform to the Quranic inheritance law as understood by the traditional scholars. According to the Quran, the mother was originally to receive 2 rupees. Under this solution, she now receives 1.6 rupees. The father's share is similarly reduced. The daughters, initially due 8 rupees, now receive 6.4 rupees. The husband, who was to receive 3 rupees, is now given 2.4 rupees. Thus, prior to all, the issue was that one heir, the husband, was being deprived. But after adopting this principle, all heirs are now deprived of their full shares according to the traditional scholars' own interpretation of the Quran. In effect, to give the husband his share, the very law of inheritance has been altered and all shares have been modified. Let us now examine the second case. In this scenario, the deceased woman left behind a husband, a mother, and 2 full sisters. According to the traditional scholars, the mother should receive 1/6 or 16.66% or 2 rupees, the 2 full sisters 2/3 or 66.66% or 8 rupees, and the husband half or 50% or rupees 6. But after the mother receives 2 rupees and the sisters 8 rupees, only 2 rupees remains, while the husband is due 6 rupees. Again, the traditional scholars apply the principle of all to reduce all shares equally. So the mother's share is reduced from 16.66% to 12.5%, rupees 1.5. The sisters from 66.66% to 50% or rupees 6, leaving rupees 4.5, which is then given to the husband, reducing his share from 50% to 37.5%. Hence, once again, the shares allocated to each heir have been altered. The mother now gets 12.5% instead of 16.66%. The sisters 50% instead of 66.66%, and the husband 37.5% instead of 50%. Thus, not a single heir receives the share allocated by the Quran as interpreted by the traditional scholars. In the third case, the deceased woman left behind a husband, 2 maternal half-sisters, and 2 full sisters. As per the traditional scholars, the Quran prescribes half for the husband, rupees 6. 1/3 for the maternal sisters, or rupees 4. 2/3 for the full sisters, or 8 rupees. Clearly, this is not practically possible with a total estate of 12 rupees. According to the traditional scholars, this issue was addressed during the caliphate of Umar, may God be pleased with him. When the full brothers came to him and complained, "O leader of the faithful, even if our father was a fool, we are the real brothers of the deceased. The maternal siblings who do not share the same father have received a share according to your judgment, and yet we, the full siblings, have not." The traditional scholars narrate that Umar, may God be pleased with him, then included a share for them. 3 solutions have been proposed based on this decision. The first solution is that the full sisters are given a share from within the maternal sisters, 1/3, but this means neither party receives the exact Quranic share. The second solution is apply all again and reduce all shares equally. What happens is that husband's share is reduced from 50% to 33.33%, or rupees 4, maternal sisters from 33.33% to 22.22%, or rupees 2.66. Full sisters then receive 44.44%, or rupees 5.33. In this approach, none of the heirs get their Quranic entitlement. Then there's third solution. Some traditional scholars suggest giving the husband and maternal sisters their full shares, rupees 6 and rupees 4. And since only rupees 2 remain less than the rupees 8 needed, the full sisters get nothing. But this is clearly in conflict with the Quran, which had allotted them a share. فَإِن كُنَّ نِسَاءً فَوْقَ اثْنَتَيْنِ فَلَهُنَّ ثُلُثَا مَا تَرَكَ. But if there are more than 2 daughters, they shall have 2/3 of what he leaves. In all 3 proposed solutions, not a single heir receives the full Quranic share as understood by the traditional scholars. Instead, each heir's portion is altered or omitted to make the division possible. To conclude thus far, we have examined the Quranic allocations as understood by the traditional scholars, analyzed the complications in their application, and critically reviewed the solutions proposed to overcome these issues. It has become clear that the solutions create even more difficulties. The shares, as interpreted by the traditional scholars, are not practically divisible, and their remedies, rather than resolving the issue, undermine the integrity of the original divine injunctions. In the next episode, we will ask, could it be that the traditional scholars' understanding of the Quranic inheritance shares is flawed? And is there a way of understanding the Quranic injunctions that entirely avoids these complications and allows the inheritance to be divided as intended?